Good morning, Haran, TIC representatives, and to all attendees joining us. Welcome to the Equal Opportunity Commission's webinar, Know Your Rights, Employment Discrimination. My name is Shani Dolabai. I am the Manager of Corporate Communications at the EOC, and I'm joined by Haran Ramkaransingh, who is the Director of Legal Services at the EOC. And Haran will be leading this morning's presentation. We are joined by representatives from legal and HR departments, as well as members of the public for quite the topical issue these days, employment discrimination. This session promises to be both an informative and helpful session for attendees. At the end of the presentation, we will set aside some time for a Q&A segment, but please submit your questions throughout the presentation and I will pull from the chat and ask Haran at the end. And so, without further ado, I pass you over to Haran.
Hi, good morning, everyone. Thank you all for being here. Well, I have a presentation, so I'm now going to try and, yes, I have to now share the screen. So I'm going to try to do that. Yes, thank you very much. Hopefully, share. Yes, you know, technology, it always takes a little while. All right, so I think we can start the slideshow, right, from the beginning. Yeah, sorry. Good. So hopefully everyone is seeing the slide. You know, we've been using Zoom for the longest while, for about a year and a half now, but it still takes me a little while to get accustomed to it. So I take it everyone is seeing the slide, the slideshow. So the topic really is discrimination, employment, and the Equal Opportunity Commission. We're here to tell you a little bit about who we are and what we do. Just before I begin, the seminar that we're doing this morning, we do similar seminars for many employers and many organizations that request that we come in. So it's not just employers, but for example, chambers of commerce. We've done seminars of this nature for regional corporations, for boards, that sort of thing. I usually would come in because it's just a force of habit. In the past, pre-COVID, we would actually go into your organization or your business or your entity and do it. Because of COVID-19, everything is now being done via Zoom or online platforms. Maybe at some point in the future, I don't know what's going to happen, if we're going to reopen or to what extent. But for the time being, we have been doing facilitating these seminars online. Last year, for example, we did a similar seminar with TIC, and we're doing this one this year. So I'm not going to try to inundate you with too much information because there's really quite a lot. For example, if ever you've been part of one of our seminars, you know, we can do either 1 hour, 2 hours, 3 hours. We can do a whole day seminar. So you know, there's enough information to take you over quite a period of time. So very briefly, who is the Equal Opportunity Commission? What constitutes discrimination under the Equal Opportunity Act? What can employers do to guard against the occurrence of discrimination? And finally, what is our investigative process? Now, we are from the Equal Opportunity Commission, and the Equal Opportunity Commission is a public body that was created by the Equal Opportunity Act. The Equal Opportunity Act was Act number 69 of 2000, and it was passed to prohibit certain kinds of discrimination. Because what we'll come to is that there are certain types of discrimination which is outlawed by the Act, but there are also certain areas that the Act does not touch on. So it's not every form of discrimination because, you know, we get a lot of complaints from a lot of persons who complain about a number of things, and in their minds, and to some extent, they might be correct. Yes, you are being discriminated against by your employer or by you know, your school or the provider of goods and services, but it is not discrimination to which the Equal Opportunity Act applies to. It was also, the Act established two institutions, the Equal Opportunity Commission and the Equal Opportunity Tribunal. We are from the Commission. The Tribunal is separate and distinct to us. They are chaired by a judge. The judge is supposed to be assisted by 2 lay assessors appointed by the president. And recent developments have made it necessary for us to stress very strongly that the tribunal is independent to us and separate from, and the commission and tribunal are independent to each other. The commission is not a part of the tribunal, nor is the tribunal a part of the commission. The tribunal is chaired by a judge appointed by the Judicial Legal Services Commission. That is the entity that is chaired by the Chief Justice and appoints all of the judges and magistrates in Trinidad and Tobago. So we are not involved with or have anything to do with any matter that he does before the tribunal or how the tribunal operates. So I think it's important to just make that distinction very clear. I always like to use the example, well, then what is the purpose of these two institutions? The commission's purpose, as I will come to, is to receive, investigate, and conciliate complaints of discrimination lodged by members of the public. You recall that the Equal Opportunity Act was passed to prohibit certain kinds of discrimination. The Equal Opportunity Act creates a mechanism by which persons who have been subjected to this discrimination can access redress. They can access, that is to say, you can lodge a complaint with the commission first and foremost. Our mandate is to receive the complaint, investigate the complaint, and where possible, bring the parties to the table for conciliation. Conciliation is really a process where you try to have a dialogue, where you try to facilitate a dialogue between the parties to see whether they can resolve it between themselves. If it cannot be resolved, then the matter is sent to the Equal Opportunity Tribunal, and they are a court. And I've just explained that at great length, at great pains, that they are a court chaired by a judge. They are independent to us, and they are not part of us, and nor are we part of them. So we would then pass the matter on to the tribunal. And when it goes there, it is as if it goes before any court, say the industrial court or the high court. You know, you have to have your lawyers. Unlike the industrial court, where you could be represented by a trade union, the Equal Opportunity Tribunal is more patterned after the high court. So you have to be represented by an attorney. And just like with any matter before the high court, you have to file your claim form, your defense, your witness statements, your evidence, your arguments, all of that sort of thing. So that's what goes on over there. Now, the proceedings before the commission are free of charge. You don't need an attorney before us. You don't need an attorney to file a complaint or to go to conciliation. But when you go to the tribunal, you must have an attorney representing you. So hopefully that explains what these two institutions are and what's the difference between them. Our vision as a commission is we see a society which is free from discrimination and prejudice, where human rights and diversity are respected, and where there's equality of opportunity for all. Our mission, we work towards the elimination of discrimination and the promotion of equality of opportunity through advocacy, public education, research, and the conciliation of complaints. So I say public education is important, because what we are doing now, for example, as a form of advocacy, is a form of public education. So that hopefully would get you to understand who we are and what we do. And as I said, so let's get into the meat of the matter. What is discrimination under the Equal Opportunity Act? You'd recall that I said the act was passed to prohibit certain kinds of discrimination. The act applies to discrimination in 4 broad categories. In the category of employment, education, the provision of goods and services, and the provision of accommodation, where that discrimination is based on a certain personal and inherent characteristic known as a status ground. The thinking behind the Equal Opportunity Act is that decisions in employment, like who do you hire, who do you promote, who do you transfer, who do you terminate, or even in the provision of goods and services, who do you give your goods or services to, should not be influenced by these personal and inherent characteristics. These are characteristics when we do these presentations, we ask persons, well, think about what are some characteristics or grounds that are inherent to you on which you could be discriminated against. And people will throw out all the classic answers, and your race, your ethnicity, your religion, your age, your sexual orientation. Now, the Act prohibits discrimination on 7 status grounds, which are listed here. And we had mentioned disability, I had mentioned ethnicity, race, your marital status, your origin, which includes your geographical origin, your religion, and your sex. Now, just a minute ago, I had mentioned grounds like age and sexual orientation. Unfortunately, these grounds are not covered by the Equal Opportunity Act. The Equal Opportunity Act covers sex, but sex and sexual orientation are 2 different things. Sex really speaks to what we call, in layman's terms, gender discrimination. That is to say, differential treatment between men and women. Sexual orientation is something that's different to that. And age is not a ground that's covered. And you would recall that one of our mandates is advocacy. We have advocated and we have recommended to the Attorney General of Trinidad and Tobago that the Equal Opportunity Act be amended to include age and sexual orientation as status grounds of protection. So that is an amendment, that is a recommendation before the Attorney General, but for the time being, it is not covered by the Equal Opportunity Act. Now, apart from discrimination on these status grounds, there's a second category known as victimization, which I will come to. Victimization really applies where someone is treated less favorably because they have done something to enforce their rights under the Equal Opportunity Act. And then there's a third category, a standalone category known as offensive behavior. In recent times, actually, if you've read the article, every Monday we have an article in the newspaper. And if you read this Monday's article, we spoke about offensive behavior very briefly. In recent times, we've gotten a number of complaints from persons alleging offensive behavior. But the complaint is really that somebody said something to me that's offensive and that's hurtful. And while if you apply the grammatical meaning, it is behavior that has offended you. So it is offensive behavior. Offensive behavior under the Equal Opportunity Act really refers to something very specific. And it is more akin to hate speech. It is more akin to where a person says or does something in the public domain that incites hatred or ridicule or scorn on a racial group or a religious group or that sort of thing. I'll come to that later on, as opposed to really behavior that's just hurt my feelings. While yes, it is behavior that has genuinely offended you, it is not really offensive behavior as defined by the Equal Opportunity Act. So I'm just going to touch briefly on discrimination on employment. And it's important to understand that employment under the Equal Opportunity Act has a very wide ambit. Normally, when you go to the industrial court, you always hear arguments being made, is so-and-so a worker within the meaning of the Industrial Relations Act, because they have a very specific and narrow concept of what is a worker. Under the Equal Opportunity Act, any form of employment relationship is covered. So for example, whether you're a candidate undergoing there's no limitation to say only manage, if you're senior management, if you're teachers, if you're police, you're not employees. Anybody can lodge a complaint. If the CEO can lodge a complaint, as well as the janitor, for want of a better word. And not just them, but persons who are candidates or apprentices. So let's just say you're an OJT, you can lodge a complaint. But these are persons who are actually in an employment relationship. But many times, where the real discrimination takes place is in not hiring somebody. So a person who is not hired may be the one who's discriminated against, as opposed to the person who's actually in the job. So that prospective employees as well would be covered under employment. And employment includes any contract of service, apprenticeship, a contract, in the High Court, attorneys who practice before the High Court will tell you there's a difference between a contract of service or a contract for services. One is an employee and one is an independent contractor. But under the Equal Opportunity Act, any form of employment relationship is covered, whether you're an employee, whether you're an independent contractor, whether you're an apprentice, whether that sort of thing. So that's very briefly what employment refers to. The provision of goods and services is also fairly wide. We're talking about the provision of any goods or services or facilities to any sector of the public or to any section of the public. And examples would be access and use of a public place, accommodation in a hotel or a guest house, facilities for banking, insurance, loans, finance. Now, I just want to stick a pin here and say that you would notice that many of these goods or services are not purely public sector services. For example, banking, insurance, loans, and finance. I should probably mention from the onset that the Equal Opportunity Act, and by extension, the jurisdiction of the Commission and the Tribunal, extends to both the public sector and the private sector. For example, there are many bodies out there, like the Ombudsman. Their remit is to only investigate complaints against public sector entities or public sector bodies. But we can receive complaints against a public sector body or a private sector body. So like, access and use of a public place will be regulated by public sector bodies. And more often than not, it would be regional corporations that regulate or grant access to the use of park and public spaces within their borders. But banking, insurance, loans, and finance is almost entirely private sector based. So let's, if you go back to what is to the top of the slide, any person seeking access or use of access to goods, services, or facilities can lodge a complaint with us. So that is the provision of goods and services. Then next we will come to the provision of education. Now, we said that any educational institution, so we're not just only concerned with public schools, but also with private schools, with paying schools, for example. Now, what the Act is concerned with, to reiterate, is discrimination on the basis of these characteristics that I had mentioned, your status grounds. If a school says that, let's just use the example, and I guess I'm going to show my age here when I talk about O levels and A levels. If a school says that in order to get into do A levels, you have to have grade 1s in a certain subject, that in and of itself is not discrimination under the Equal Opportunity Act, because that is not based on your race, your religion, your ethnicity, that sort of thing, but that's really based on merit and ability. But we have received complaints in the past where they said that, you know, this school is only taking in students from a certain area or from whose parents, you know, of a certain ethnic or religious background. And that could be discrimination. But it is important to note, however, the Equal Opportunity Act makes a specific exception for what is known as the Concordat. That is to say, the agreement between the state and the denominational boards by, as I'm sure, well, all persons in Trinidad and Tobago would be familiar with it. Under the Concordat, what we call traditionally the board schools or the church schools, they retain a 20% choice in admission, so that within that 20%, they can choose who they want, you know, whether they're adherents of their religion, that sort of thing. And it also makes a general exception. Well, the Act makes a general exception for the Concordat. So, because also under the Concordat, these schools can, you know, have a power of saying who they want to promote us into the post of principal and vice principal. Again, they tend to prefer persons from their faith. Now, ordinarily, under ordinary situations, that would be discrimination on the basis of religion. So if a Catholic school is saying that, you know, we are only going to promote a Catholic person into the principal, I'm just using this as an example, I'm not spotlighting anybody, then ordinarily speaking, that would be discrimination on the grounds of religion. But because the Equal Opportunity Act has made this exception for the Concordat, the specific exception, then, you know, then persons can't lodge complaints that, you know, in the 20%, they're only taking the Hindu schools, are only taking the Hindus, or the Presbyterian schools are only promoting the Presbyterian, you know, teachers, that sort of thing, because there's a specific exception for the Concordat. So this is really, that's discrimination on the basis of education, which I'm just touching on these areas very briefly. You know, so we could go into each of these areas. We can go into in a topic by itself. But, you know, as I said, I just want to give everyone a brief sort of overview so that you can get an understanding of what are the areas. And finally, there's discrimination on the provision of accommodation. According to our statistics, really, this is one of the least utilized areas. But perhaps it is an area that you find fairly common in Trinidad and Tobago. A person shall not discriminate against another person on the terms on which she offers accommodation by refusing the application or by deferring it. You know, many times you hear people saying, when they call on the phone, the person says, yes, the place is available. But when they turn up, then you find out, no, it's not. And then this is an ad we saw on the classified. Well, somebody brought it to our attention. 2-bedroom, Faizabad AC, East Indian couple. Now, the equal opportunity, so that is, on its face, it would point to discrimination on the basis of race. However, it is important to know that the Equal Opportunity Act also, just as I mentioned that there was an exception for the Concordat in the case of education, the Equal Opportunity Act makes a specific exception for properties where the owner resides. So, you know, in Trinidad, it's very common where, for example, a person has a two-story house, many times you might find the owner lives upstairs and downstairs they have either one or two apartments to rent. Now, if the apartment is located in the premises where the owner resides, then the Equal Opportunity Act specifically says that that this is accepted. So that, well, you know, they had raised this example with us, so we never bothered to telephone or call. But if using this example, this 2-bedroom is actually in the owner's premises, then it is exempt from the provision, or it is beyond the reach of the Equal Opportunity Act. So the thinking behind it is a man's home, or to be, let's be equal, a woman's home is their castle. So that if I'm living in a house, I should have a complete choice as to who I rent a space in my premises to, because this is my space. You know, I guess so. So to some extent, the Equal Opportunity Act, while it tries to create certain conditions, it does also recognize the reality of life in Trinidad and Tobago. For example, as I said, in Trinidad and Tobago, the Concordat is part of our fabric. You know, so and in Trinidad and Tobago, it's also part of our fabric that people rent apartments or premises or places in the where they reside. And so again, it's not everyone might agree with it, but as I say, it is what it is. Now we come to race and ethnicity. people tend to use these words interchangeably, but social anthropologists will tell you that there is a specific, there is a distinction between them. Race refers to, the biological or physiological characteristics, such as that, race is defined, by these biological and physiological characteristics, such as hair color, the color of your skin, these sorts of things. Whereas status, not status, what am I saying? Whereas ethnicity is really defined by social and cultural characteristics. So that's why if you go back to the example, we can say race is purely physical, what you look like physically, but ethnicity is how you identify with culturally. An example I always like to use, all of the persons from West Africa would be of the African race, but then you would see here people identify along certain tribal lines, the Igbo tribe, the Mandingo tribe, the Orisha tribe, all of these tribes. And so tribal identification is really seen more as ethnic, because again, if you go back to race, race is biological, and biologically they're all persons of the African race. But what distinguishes one tribe from the other might be certain things like their manner of dress, the types of foods that they eat, certain cultural practices that are associated with them. For example, in West Africa, you might find that the women of different tribes wear certain types of jewelry, or they tie their hair differently, or they have certain dance and certain musical traditions. So these are what you say when we look at the cultural heritage or aesthetic traditions. These are the things that you identify with as an ethnic group, as opposed to a racial group. So that's just something to think about. And when we come to sex and gender, we will also see sex is seen as biological, whereas gender is seen as, it can be seen as cultural or social. Religion, I think, is fairly self-explanatory. A question that we always get asked is atheism or agnosticism covered by the Equal Opportunity Act? In other words, religion speaks to the existence or the veneration of, of a supreme being, or following certain, traditions or practices, whereas atheism or agnosticism is really the rejection of these beliefs. We've never had a matter that really challenge that really raises question. In other countries, their equal opportunity legislation specifically includes atheism and agnosticism. So I guess this is something that it's food for thought whether it is included or not. Now, origin, remember we said includes geographical origin. So, but we have interpreted origin to mean basically where you originate, where you come from. So it could include your ancestry, your parentage, that sort of thing. For example, we had received a complaint and we had investigated it, and we had referred it to the Equal Opportunity Tribunal. It's not been heard as yet. A complaint where somebody said that, they were denied participation in an event because of who their parent was. They were specific. This is the allegation. The respondent has denied it. But let's take the allegation purely at face value. The allegation is that they were told that they were not welcome to participate in an event or at a venue because of who their parent was. So we have interpreted that to mean, well, that would be discrimination on the basis of your origin. It may not be on the basis purely of your geographical origin, but it's on the basis of your ancestry or parentage. Again, and it accords with our thinking that the Equal Opportunity Act seeks to protect against discrimination against characteristics which are inherent to you, over which you have no control. You have no control over your race, your sex, that sort of thing. And along that same thinking, you have no control over who your parents are. And you should not be discriminated based on your race or your sex, and similarly over who your parents are. Now, things like religion and marital status, you could say, yes, well, I could choose to be single, I could choose to be married, or I could choose my religion, I could choose to be Hindu or Catholic or Anglican or Presbyterian or Muslim. But then also, where's, for example, with race and sex and origin, these are things that are beyond your control. You do have some control over these things. So but at the same time, it is inherent to you. You should not have to choose to give up your religion, or should be forced to give up your religion. Similarly, you should not be forced into saying, I am going to have to terminate my marriage or get married or stay in a marriage I don't want to stay in because of my job or because of my, or to access goods or services or education. Because again, your marital status and your religion while there is an element of choice, it is still something that is deeply inherent to who you are as a person. Marital status means whether you're single, you're married, you're living separately, you're divorced, you're widowed. I had mentioned amendments to the Equal Opportunity Act. I had mentioned we said we wanted to add age as a status ground and sexual orientation as a status ground. We've also recommended that the list of marital status be amended to include cohabitees under the Cohabitational Relations Act, because that is also now a recognized marital status, because that was an act that was passed. That act was actually passed before the Equal Opportunity Act, and we don't know why it was omitted. It was probably just an oversight, but being a cohabitee is now recognized as a status ground. But isn't that in our laws, that is, it's recognized in our laws, but it's not recognized under the Equal Opportunity Act. And you would recall I had used the example of race and ethnicity to say race is really biological and physiological, whereas ethnicity is social and cultural. Similarly, and I had said sex discrimination does not include sexual orientation. I said that early on. Very briefly, sex refers to biological and physiological characteristics that define male and female, and biologically, doctors recognize three sex, that is male, female, and intersex. Intersex is not transgender. Intersex is based on your biological and physiological characteristics. It is a small percentage of the population, but it is biologically recognized. And doctors will have what the markers that they use to determine what is your sex. For example, your reproductive organs, your hormonal profile. You know, men present with higher hormone, certain greater percentages of certain hormones than women. I mean, this is something that, again, we're talking about medical textbooks here. You know, your medical textbook will tell you this is what defines a male, this is what defines a female, and this is what defines intersex. So that is what sex discrimination is concerned about. But as I had mentioned, sex is different than gender. And going into this area, I just wanted to stick a pen and note that the University of the West Indies has a whole department, the Institute of Gender and Development Studies, that is dedicated to gender. So that talking about sex and gender and sexual orientation is something that persons can write theses on. In fact, the director of the IGDS, Dr. Gabriel Hussein, is now our current vice chair of the Equal Opportunity Commission. So I'm just saying this to say that this is an area that we can talk the whole day about, really. What is gender and what is sex? Very simply, sex speaks to male or female, whereas gender speaks to masculine or feminine. And it has to do with socially constructed norms. For example, you would hear a shirt is considered a masculine, but a blouse is considered feminine. Really and truly, there's nothing, if you know, when you take it up at a purely physiological level, there's nothing about a shirt or a blouse that makes it either way. It just has to do with the societally constructed norms. For persons or students of history, if you go back to the time of the French Revolution, you'd remember all of those persons, you know, the French kings and the French nobility had these very elaborate dresses, means of dress. The men wear wigs and wore heavy makeup and wore high heel shoes, you know, during that era. You think about Oscar Wilde, all of these sorts of things. And then you say, so I'm just saying, what are gender norms? What is gender is based on what is socially acceptable, and gender norms would change over time. So that, for example, during that period, you would hear that, you know, those types of clothing were considered masculine. You know, so I'm just using that as an example to say where sex is biological and doesn't really change, you know, gender is something that changes over time with what is socially with the social construct. So that your natal sex, and we speak about your gender. So all of these go up into making a person's identity. There's your natal sex, your gender, and then there's your sexual orientation, which, as I mentioned, is a completely different area. And we have, just to repeat, we have made a recommendation to include sexual orientation as a ground of protection. And then we have disability. Disability means the total or partial loss of a bodily function, a malfunction of the, you know, or disfigurement. And I just want to go back to say, including a mental or psychological disease or disorder, because when we see a person who is an amputee or presents in a wheelchair or that sort of thing, then we conceptualize that person as being disabled. But a question we've always asked is, how do you as an employer treat with someone who's exhibiting signs of paranoia or schizophrenia or bipolarity? Because that is also a disability. It's not a physical disability as a care, but it's also a disability. You know, according to Professor Hutchinson, you know, 1 in 4 persons in Trinidad and Tobago is afflicted by mental illness. And, you know, and so it's something to think about. And in terms of disability, the Trinidad and Tobago has signed on to the United Nations Conventions on the Rights of Persons with Disability, which is a 2004 convention. And coming out of that convention, one of the things we saw was a shift in language. So for example, in the past, say in the 80s, 90s, you would use the word disabled person. Coming out of the convention, we have now shifted the language to a person with disability. And now it might be the same nouns, person and disability, but the thinking is you identify them as a person first. So instead of saying that you're a disabled person, your thinking is you say you are a person first. You're first and foremost a person. So we say a person with a disability, a PWD, instead of a disabled person. So I'm not going to go into all of these things. Again, we can do really long presentations on this area. It's important to note that the Commission has published guidelines for employers on disability in Trinidad and Tobago. And these guidelines are available for download on our website free of charge. So that I know time is running, so I'm not going to speak much more in this area other than to tell you that it is something that you can look at. You can go into our website, you can look at our guidelines. And this is an area as well that, as I said, we can do a lengthier presentation on. There are a number of exceptions to the Equal Opportunity Act to what was created, but I'm not going to go into that. Again, and I spoke about this, so that's discrimination on the 4 broad categories on the grounds of status. Victimization really occurs where a person is being treated less favorably. Let us say you have lodged a complaint with the Commission, or you have indicated that you intend to do that, or co-worker has lodged a complaint and you are supporting that co-worker, or even if you have just simply made allegations to your employer that, look, what is going on here is discriminatory, and coming out of any of these things, you are being treated less favorably by your employer, then you can lodge a complaint for what is known as victimization. We get a lot of complaints about victimization, where the person feels that your employer or somebody is doing something mean or malicious to you and you feel like a victim. And as I said, it is in the ordinary sense of the word, yes, you do feel like a victim, and your complaint is not an invalid complaint, but it is not victimization under the Equal Opportunity Act. Under the Equal Opportunity Act, victimization has a specific meaning. And you require, I've spoken earlier about offensive behavior, and I said that we've been getting a lot of complaints about persons who said, well, so-and-so did something that hurt my feelings. And yes, it is hurting your feelings, but offensive behavior is more along the lines of hate speech. It occurs where a person shall not otherwise than in private. So if it's in private, yes, you can do it. But if you do it in the public domain, for example, if you say something on in a TV show that's being broadcast or a radio show, you write it in a newspaper article, or even now with social media, you say something on a video that's uploaded to YouTube or TikTok or Facebook, and what you've done is reasonably likely to offend, insult, humiliate, or intimidate another persons because of their gender, their race, ethnicity, their religion. Just stick a pin. The section speaks about gender, and so we've interpreted it to mean that gender in the wider sense. Yeah, so and it's done with the intention of inciting gender, racial, or religious hatred, then you can lodge a complaint of offensive behavior. Now, this is not tied to any form of employment or education or goods or services. This is simply where someone has said or done something in public that constitutes hate speech, because it has to be done with the intention of inciting hatred. Hate speech against a religious group, a race, or a gender, then you can lodge a complaint really about this form of what we call hate speech. What can employers do to guard against the occurrence of discrimination? Just as we had published guidelines for guidelines on disability, we've also published guidelines for employers in Trinidad and Tobago about anti-discrimination law, prohibited practices, and what can you do if a complaint is made against you. We always say, try to avoid using status grounds in your recruitment. For example, male employees needed in a plant shop. Now, we just picked on these just to show you. It may be that, yes, you need an employee to do in a plant shop. So let's give them the benefit of the doubt and say you want somebody to do heavy lifting. You have to lift bags of soil, heavy palm trees, that sort of thing. Then that's fine. But, what we would tell you is, rather than saying a male employee, you should say employee needed to do these things, for heavy lifting. The reality is that you might get all of the applicants might just be male, but you never know. I mean, there might be a female who is perfectly capable of doing the job. Now we know this is a classified ad, and so we're just using this to try and use it as a teachable moment to make a point. So we say ad should be as neutral as possible. For example, I always like to speak about this front. Security officers required for a company located in Karanaj. I always like to compare it with laborers needed in and around Point Fortin. Now, this would be discrimination on the basis of geographical origin if you're saying that you're only hiring laborers in and around Point Fortin. Whereas when you look at this one, security officers required for a company located in Karanaj. So we say the company is located in Karanaj. You could be from Arima, you could be from Sangre Grande, you could be from Trigonis, you can apply. But the company is located in Karanaj. And when confronted, using this example, people have asked us, but we want persons from our area because they will get to the office on time, and we say, well, this is really something that you would have to manage as in your human resource department. If you say the company is located in Karanaj, you need to tell the person, well, your job spec requires you to be here at 7 a.m. or 6 a.m. in the morning, and this is what you're required to meet, as opposed to saying, well, no, we're not going to hire you because you're living too far away. We have a list of questions we say that you shouldn't ask in a job interview. Again, this is an area that we can go into in a lot of detail. It's all of this can be found in our guidelines for employers. And what we also like to touch on very briefly is that we've also published, there are 3 guidelines we publish. We publish guidelines on disability, we publish guidelines on employment, and we publish guidelines on sexual harassment in Trinidad and Tobago. We have done presentations purely on sexual harassment. So as I said, this is an area that you can look at in and of itself. What is sexual harassment? Very briefly, it is an unwelcome sexual advance, unwelcome request for sexual favors, or unwelcome conduct of a sexual nature that makes a person offended, humiliated, or intimidated. We say that there are generally 2 situations. What is called a quid pro quo situation. For example, where a person is being asked for sexual favors in return for a benefit, like they're being asked for sexual favors in return for promotion or being hired or that sort of thing. And the second situation is where there's a hostile environment, so that whereas they're not being asked for sexual favors in order for their job, they're being subjected to such abuse because of the nature of the environment that they feel uncomfortable. And we also like to note that sexual harassment is not just a male boss, harassing a female in person. But if person can be the same sex, it could be male to male, it could be female to female, or it could be female to male. That's what and it can be vertical, that is a manager to employee, or it can be horizontal, that is persons at the same level. Again, this is a presentation that we can do all on its own. The last takeaway on sexual harassment is we always like to say sexual harassment in the world of work versus sexual harassment in the office. The reason being that sexual harassment could take place not just in the office, but it could take place outside of the office, like at conferences and training sessions, at work-related social activities. Sometimes it could be a proposition that takes place. The person asks, let's go out to lunch, and then at lunch, this is what happens: communications, company vehicles. So that's why. So we just say this to get you to think about sexual harassment, not just in the world, not just as an office-based event, but something that happens as a work-based event in the world of work. And all of these, like the complaints mechanism, all of these things are things that we can discuss. We have discussed in our guidelines. These are just some of the matters that have gone to the tribunal, that have garnered newspaper attention. I know there are a number of questions. So with this in mind, I am going to bring this aspect of the presentation to an end. And I'm going to bring this aspect of the presentation to an end and go strict, because I know we have about 15 minutes again. So let us go straight into the questions and answers. If anybody has any questions, any queries, any comments that they would like to raise, please.
All right. Thank you, Haran. We have quite a bit of questions, actually. So I just want to get right into it. Someone asked, I'm interpreting the question here. Does the Equal Opportunity Act cover women who are discriminated against because they do not have children?
Well, going back to marital status, it actually lists single, married but divorced. Children and caregiving status is actually not covered under the Equal Opportunity Act. So saying that if you are discriminated against because you Well, the question we normally get is people who are discriminated against because they have children. I've never really considered a situation where you're discriminated against because you don't have a child. So I perhaps maybe the person were to give an example of what it is they're thinking about, but specifically speaking, any status relating to children or caregiving is at this point not covered by the Equal Opportunity Act.
All right. The next question is from Candice Frederick, and she asks quite a bit of questions. So if we have some time, we'll come back to some of these. But I picked out the question that says that the recommendation to include age and sexual orientation in the Equal Opportunity Act seems to be stagnant for a while now. Why is that?
Well, it's really something that's, to be perfectly blunt, is beyond our control. With respect to sexual orientation, the Attorney General has specifically said that there was a matter that went to the High Court about 3 years ago, Jason Jones versus the Attorney General, where the judge ruled that the provision of the Sexual Offences Act that criminalize homosexual conduct is unconstitutional. That matter has gone to the Court of Appeal, and it will eventually go to the Privy Council. The Attorney General has said that he's not going to, he actually, there was actually a news report earlier this year where the Attorney General specific, and you can Google it, he said there are about 27 laws that impinge on sexual orientation. You can, if you Google 27 laws on Attorney General, you will come up with it. He didn't list the Equal Opportunity Act, but it is one of them. I mean, there's the immigration laws, there are all sorts of different marriage laws. And he said he's not going to deal with any of these laws until that matter has gone all the way to the Privy Council. And so that's somewhere in train, but that's likely going to take a few years again. So that is the status of that matter.
All right, thank you. Someone asks, well, someone said actually, it's not really a question, but maybe you may want to address or advise on it. Since I filed a case with the EOC, the discrimination and other actions has increased drastically, where I have become ill and I'm currently on sick leave due to mental anxiety. A colleague in the HR department told me that this is being done deliberately by management because I went to the EOC, and I'm not certain how much more I can cope with the discrimination. Is there any advice? Okay,
all right. Well, if it is that they have done things to victimize you, then you can lodge a second complaint of victimization. But also just looking at the flip side, you know, when you file a complaint, it is going to cause, you know, there will be stress and tension between yourself and your employer. So it is something that you would have to be prepared for. So, you know, if it is, for example, after filing your complaint, they transferred you or they took away some benefits that you had, even if it's as simple as vacuous, for want of a better word, as a parking spot or a company cell phone or a laptop, or they took away a working laptop and they put you in an empty office. These are second complaints that you can lodge of victimization. So you know, those are separate complaints really.
Okay, someone says that she wants to know the power of the EOC, and I want to interpret that to mean whether or not the EOC has any teeth in terms of are there sanctions, or can we make a respondent respond to a notice? So let's say someone files a complaint against a huge corporation.
Yes. Well, to begin with, as I explained, I mean, our mandate is to conciliate complaints so that we can't make judgments against a respondent. That is the job of the tribunal. So while the EOC doesn't have that power, the Equal Opportunity Act vests that power on a second institution, which is the tribunal. So that when people come to the table for conciliation, it's really for a discussion between the parties. And if I'm just being blunt, if your employer says I don't care to resolve this matter, there's nothing that we can do to compel the person. The powers that we have are really powers with respect to our investigation. So let us say we send we are empowered as part of our investigative process to send a notice to someone, and it could be any party, and ask them to provide us with certain information. If they fail or refuse, we can take them to the magistrate's court and have them fined by a magistrate. Currently, we have one matter that's ongoing before the magistrate's court. But at the same time, we don't have the power to issue a fine. Like, you know, the Environmental Management Authority, I'm just using them as an example. They have the power to order a compliance notice on you. And if you don't comply, they have the power to fix a penalty. We don't have the power to fix a penalty, but we do have the power to to carry you to the magistrate's court and prosecute you if you do not comply with our notices to provide information. But those powers really, really affect those are powers concerning our investigations. Excuse me. It is not a power to either fix a penalty. It's not a power to order that the employer or whoever does something, but the tribunal has the power to order your employer do X, Y, Z, or pay you compensation or that sort of thing.
Okay, thank you. Someone asked in the Q&A feature, the recent decision by some privately run institutions to discriminate against members of staff, not accepting their terms and conditions of employment, who are not vaccinated. Also, although it's not mandatory by law, it's a little. Okay, they want to know if action could be taken against these institutions by the EOC, basically.
Okay, I just muted because I mean there are lots of sirens blaring on the road. That's just one of the challenges with working from home. The short answer, I mean, this is really the hot topic right now. I mean, what can be done with respect to vaccinated or unvaccinated persons? Our chairman had made a statement about it, and it was echoed by the president of the industrial court, that an employer cannot alter the terms and conditions of existing employees. Now, many employment relationships out there, like for example, in the fast food industry, not, you're not like, for example, an employee of a bank that you have a permanent, a 3-year contract, a 4-year contract, or you have a permanent status. So that, for example, those persons might be able to insist on certain things. If it is your employment is on a, say, a 6-month contract or a 3-month contract, or on a transient nature, you're being furloughed and you're being called out, but you don't have a definite monthly status position, if you're daily rated, that sort of thing, they might have the ability to at least alter your terms and conditions, because every contract is seen as a new contract. But if you have something of a more permanent nature, like you're the employee of a ministry or a bank or that sort of thing, no, they can't insist on, they cannot alter the terms and conditions of your employment. But if you're a contracted person and your contract has come to an end, that they can renegotiate and put new terms and conditions in a new contract. Just recently, we received a complaint from someone who was complaining about discrimination based on being unvaccinated. Being vaccinated or unvaccinated, unfortunately, is not a status ground under the Equal Opportunity Act by itself. In order to lodge a complaint with us, you would have to pigeonhole yourself, for want of a better word, into one of the existing status grounds, which, as I recall, a race, ethnicity, religion, disability. And I'll stick a pin right there. Disability really might be the only status ground you can go under, because you really can't say you're being discriminated against based on your race, unless you can actually point to race discrimination, which is that the employer is allowing unvaccinated people of a certain race to work, but unvaccinated people of a different race are being treated differently. Then your claim is really one of race discrimination rather than a vaccine discrimination. But if it's purely one of vaccinated or unvaccinated, you can claim disability if you are unvaccinated by reason of a medical condition. That is to say, on the basis of medical advice from a doctor, you were told that you cannot take the vaccine because it's likely going to adversely affect an existing medical condition. Then you can lodge a complaint with us that I'm being discriminated against because of my existing medical condition. Yeah, existing medical condition prevents me from taking the vaccine, and because of that, I'm being discriminated. If you're pregnant or a nursing mother and you've been advised against the vaccine, then you could actually claim sex discrimination, because discrimination against a pregnant woman is seen as a form of sex discrimination. The thinking being that only women become pregnant, so only women can suffer this detriment. But if your unvaccinated status is really because of vaccine hesitancy, while this is a choice that you are free to make, the Constitution guarantees you freedom of choice, it is not by itself a status ground under the Equal Opportunity Act. So we may not be able to take a complaint of discrimination on a vaccination of being unvaccinated, where it is purely based on a choice ground, as opposed to being based on a medical ground.
Okay. Someone also asked, does the EOC interact with HRMAT to bring awareness? That's the Human Resource Management Association of Trinidad and Tobago, to bring awareness on employment discrimination to our country's human resource managers, who are charged with developing human resource policies in the workplace, also with trade unions who seek to protect workers' rights.
Yes, well, actually, I think you could have answered that question. We interact regularly with HERMAT and the ECA. In fact, I think just about, well, you might remember the date, about 2 or 3 months ago, we had a session with HERMAT. HERMAT had invited us to present on a session. I don't remember the date, you probably remember it. It was actually on that same topic of vaccine and COVID-19. They had a session on it and we presented. And the ECA had a session. We had a session with the ECA. Shelley, you remember? I think about 3 weeks ago, was it?
Harassment a few weeks ago.
Yes.
Yes. So the answer is yes. You can also request a session with us using communications@eoc.gov.tt. I will put it in the chat. I saw a few other questions on vaccine discrimination, but I think you would have covered it, right? Someone else asked, someone else said, is it that persons discriminated by reason of their sexual orientation are then without a remedy in TNT?
Well, you would have to try and fit your situation into something existing. Let us use the example of the industrial court. If you are an Industrial Relations Act, if you are fired from a job because of your sexual orientation, then that might be an industrial relations issue. If, for example, your employer did not follow due process, did not say what their disciplinary issue was, did not hold a hearing against you. So using that as an example, you may have a remedy there. So it's not that you're completely without a remedy, but you would have to try and pigeonhole it, for want of a better word, within another existing state of affairs, so that, if you're fired or if you're not promoted, then you might be able, and you are in a unionized environment, you may be able to take the matter to a trade union who can then report a trade dispute to the industrial court. But outside of that, then under the Constitution of Trinidad and Tobago, you're guaranteed equality of treatment. So let us say you're treated adversely by a government agency because of your sexual orientation. You might have to hire an attorney to file a constitutional motion. That's something that's been part of our legal language for many years. You file a constitutional motion against them in the High Court. But again, this would involve some resources on your part, because you would have to, find an appropriate attorney who's skilled in that area and take them out to the courts.
Right. Someone asks, has there ever been a complaint presented to the EOC that the respondent has admitted to wrongdoing?
Well, in conciliation, the respondent may not necessarily admit to wrongdoing, but they would try to resolve the matter. Because actually in conciliation, sometimes, you can agree with your employer for an apology. These are things that you can agree to in conciliation. So I actually don't sit into the conciliation process. The conciliation is handled by an in-house conciliator who is a licensed mediator registered with the Mediation Board of Trinidad and Tobago. And conciliation is a confidential process. So neither Shelley or I would actually be sitting to the process, and neither Shelley or I sometimes would know, more often than not, we don't know what happened or what was the resolution. But yes, it could happen at conciliation because sometimes, what the citizen wants or what the person wants is an acknowledgement of wrongdoing from the employer. And if the employer is willing, or the person who might have wronged them, not necessarily an employer, but goods or services, landlord, school. And if the person is willing to do that, then yes, that can happen. But at the same time, sometimes the person is just maybe wrong and strong and say they're not willing to do it. And going back to the question, what power the EOC has, the EOC cannot force somebody who's wrong and strong to give the apology that they don't want to give.
I have a very interesting question here, Haran, that I've never seen pop up before. Would the need to hire Fenceline residents for a project be considered discrimination?
Fenceline residents as in
residents.
Okay, who live close by, yes.
Right.
Yeah, I understand. Yes, it would be if your main criteria is saying that we are only hiring persons from this area. It will be discrimination on the basis of geographical origin, because that's what the Act provides. Using that same Petrotrin and Trinma and the plea classified ad I had put up, We had done sessions with somebody and they had pointed out that a lot of the companies that operate in Point Fortin, part of their concession is, and part of the agreements with their trade unions is that they will favor persons from that geographical area. Now, we've never had a complaint coming to us. I mean, it's never gone to the Equal Opportunity Tribunal, but in and of itself, it will be discrimination on the basis of geographical origin if what you're saying is that you're only hiring or you're preferring persons from this geographical area. If what you're saying is that, I'm just going to use this example, we need persons who can start at 6 a.m. on a job, and if that is the requirement of your job, then you need to state that. So if you are based in San Fernando, a person who lives in, say, Sangre Grande or Toco or Manzanilla will have to make the choice that it's not possible for me to get here at 6 a.m. And you would have to make that conditional in their contract so that they can't turn around and say, well, look, today there was a strike, there was a maxi taxi strike. I have to rely on public transport and there was a maxi taxi strike or something. It is something that you would have to make an essential term or condition of their contract that, sorry, they are required to get on the job at 6 a.m. because that sometimes is the main reason why you would want to hire a fence line person as a person who's living 50 miles away. But you would have to actually stipulate that in your employment contract that the requirement is they must be on the job at 5:30, 6:30 as it were, as opposed to saying no. We are based in Point Lisa, so we're only going to hire people from that area.
Yeah, I see a few people asking whether or not the presentation will be made available, and it's being recorded, and we will post it to our Facebook page, LinkedIn page, website, and YouTube page as well, so you can look for it there. Someone asked, can employers decide that internal certification is not required as part of your job? This was not a condition of employment at the time of hiring.
Well, it is something, no, it's a yes or no question, because many professional bodies, especially professional bodies that are affiliated with England and the United States, like the accountants, have what is called CPD. That is to say, you must do continual professional development to maintain your status as an accountant. The Law Association of Trinidad and Tobago, I used to be on the council many years ago, had given thought to it, but we've never implemented it. It is something that they hope to implement in the future. In other words, to maintain your certification as an attorney at law, you must do X amount of CPD hours. I know the medical board is also thinking about it, but again, I'm not aware of any professional bodies in Trinidad and Tobago that have implemented it, but they've all been thinking about it. But I know the English-based bodies like the ACCA bodies, they require CPD. But then again, this is something that every year they are entitled to change their matriculation requirements every year. Your employer cannot insist on something that it was not part of the initial contract of employment. But I just want to flip it around. Let us say your contract of employment is I'm hiring you as an accountant, and you lose your certification as an accountant because you did not do your CPD or what have you, or you lose your certification as an attorney because if and when it does come into place, you didn't do your CPD, then they can say, well, you are no longer qualified for the job that I've hired you for. So it is something that is inherently linked to the qualifications for the job. If the qualifications for the job coming in, and look, you just need to have a BA degree or BSc degree, I'm just saying something, a degree, and you presented your degree, then they can't insist on further or new qualifications for the job. But they can, but if you are employed on contract, when they are renewing or renegotiating your contract, they can make it a term of your new contract, but they can't renegotiate an existing contract to that effect.
All right. Someone asked, two teachers go for an interview for promotion in a public school. One teacher is due to retire in 3 months' time, but is granted the position in the teaching service. The younger teacher, who has been acting in the position for 4 to 5 years, is not given the position. Can you please advise?
Well, that in and of itself, I mean, while the person may feel discriminated, unless you can tie it to a status ground, it is not really an equal opportunity matter. It is a public service matter because, well, I say public service, meaning the wider public service. It might be an employment matter where your remedy might be, I'm just saying, to file a judicial review against the Teaching Service Commission because it was a decision of the Teaching Service Commission. Unless you can say this happened because of your race, your religion, your ethnicity, because you said it's a public school, so you really can't point to religion to say that the school board said they preferred the person from their religious background. Yes, I mean, in your mind, you would feel you're being denied equality, but again, to go back to what I said at the very beginning, the Equal Opportunity Act is really concerned with discrimination on certain grounds, so that unless you could tie it to your race, your disability, your sex, that sort of thing, then it may not be a matter for the Equal Opportunity Commission. It may be a matter that you need to speak to an attorney and consider whether or not you can take action against the Service Commission. Because from what you said, it's a decision of the Service Commission. You would have to begin with, you would have to make an application under the FOIA to get the score sheets, because if that person scored higher than you, then you would have to see why it is they scored higher than you. That's something that an attorney would have to advise you on.
Yeah, I'm really trying to get as many questions in as possible, and if we weren't able to answer your question, or you have additional questions, every other Wednesday we do a Facebook Live series where Haran would come on and answer questions as well. So you can also look out for those opportunities. Someone else asks, can an employer, and I guess this will also be related to origin, can an employer relocate an employee without the employee's agreement, even though the contractual agreement between both parties was for a specific location? The employee would have highlighted the drastic inconvenience the move would cause. However, the employer never considered it.
Okay. All right. That's really a question of employment law rather than discrimination law. If that's a term and condition of your contract, then the employer may not be able to do it unilaterally. But if let's say the employer, my job was for a location in Tunapuna. I'm just using this example. My contract said that, but the employer has closed down the Tunapuna plant or the Tunapuna location. Then the options are either to offer you a job in, say, if they have their location is Arima, or to retrench you, because so those are really the two options. There's either if it is they've closed down the Tunapuna branch, or if it is they have, if it is your employment was specifically for Tunapuna, I'm using, then they would be in breach of their contract of employment. But that's not really an EOC matter. It's really a matter for you to get an attorney to perhaps write to your employer, or trade union matter. If your organization is unionized, then your trade union would have to intervene on that. We did, however, receive a complaint from somebody who made a similar allegation, but they were able to tie it to discriminatory grounds. They were saying that it was an act of discrimination against them based on their race or their ethnicity or their whatever that characteristic was. So if you're saying that my employer has relocated me based on that characteristic, or as a retaliation, based on doing that, then that would be a discrimination matter, as opposed. But if you're asking a purely contractual question, can they relocate me when my contract says X? That is an employment law question, which an attorney would have to look at the facts and advise you on.
So I'm going to ask a two-part question, so I'll give you each question. In your opinion, the issues mentioned that are not covered by the EOE, do you see these as a shortcoming? They seem to leave a lot of room to allow for some loopholes. Do you think there is more room for it to be more progressive, as in the Equal Opportunity Act?
Well, yes. I mean, the act was passed in 2000, and at that point, for example, if you were to really Hansard debates, the provisions on offensive behavior actually, it took a lot of debate in Parliament because they saw it as something very far-reaching. So at that point, it was very far-reaching, and one of the Commission's mandates is actually to make recommendations for amendments. So the thinking was that we would be making recommendations on a regular basis. I mean, we have been making recommendations, but one can only recommend. It is beyond our control. So it is a work in progress. I do see it as a work in progress. But when it was passed in 2000, the second slide or third slide I had was a picture of a judge from the United Kingdom named Baroness Hale, who was a judge of the House of Lords in the United Kingdom. And she, in her capacity in the House of Lords, she sat on the Privy Council to hear a matter called, the name escapes me. He was one of our commissions, Kenneth Surratt versus the Attorney General. This was a matter that Mr. Surratt took to the Privy Council in 2007. And in 2007, the Privy Council ordered the government to implement the Equal Opportunity Act to create the commission and the tribunal. Although it was passed in 2000, so the government that came afterwards did not want to actually implement it. That was a fact. So that they did their best to not implement it, and they had to be forced by the Privy Council to implement the act and to create the commission and the tribunal, which is what they did in 2007. So it is a work in progress. And when you look, we have to look at it as taking steps, just like baby steps. They say you have to crawl before you walk. So this is really where we are. Yes, so.
Yes, and also that before the Equal Opportunity Act, there was no legislation that specifically addressed discrimination. And so if, Haran, do you want to elaborate on that?
Well, the only avenue you had, and I had mentioned it before, was to file a constitutional motion, but the Constitution only applies, and I had mentioned this, to public bodies. So for example, if you're being discriminated against by the Teaching Service Commission, to use that example, or by the Police Service Commission, by the immigration authorities, by, that sort of thing, any public body, you could file a constitutional motion against that public body. But as I using the example of the lady with the Teaching Service Commission, you would have to hire a lawyer, and it's a very lengthy process, and it's whereas the Equal Opportunity Act was passed to create a much simpler process by which anybody can just simply lodge a complaint. Because once you file a constitutional motion, it becomes an adversarial matter in the high courts.
Someone asks, right?
Yes.
On the COVID-19 vaccine, isn't penalizing staff by locking off your access until you either provide a PCR test every 2 weeks or vaccinate? Discrimination. The company I work for has forced persons to take vacation leave and no pay leave until such can be provided. What are my rights?
It really is, as I said, being unvaccinated by itself is not a status ground under the Equal Opportunity Act, unless you can tie your unvaccination, your non-vaccination, to a medical ground, or to, in which case it will be disability, or to pregnancy, in which case it would be sex-based discrimination. It is a genuine issue that a lot of employees are raising. It is an issue that is facing a lot of people in Trinidad and Tobago. But as is right now, it is not an issue that really falls within the Equal Opportunity Act if it is your employers discriminate against you because you are unvaccinated. As we said, if it is, they cannot impose new terms and conditions on you that were not part of your contract of employment, so that that might be a breach of contract matter. But in and of itself, no, they can't force you to provide a PCR test every 2 weeks. And so it is something that you would have to decide whether or not you want to take it any further. Right now, I know there's a matter before the industrial court between the Union and Republic Bank. So there's a Republic Bank matter that we're all awaiting on to see, what the industrial court will decide.
Yes. And once again, for those whose questions we couldn't get to, because I believe we have to close off the session very soon, you can join us on Facebook next week, Wednesday, 11 a.m., and we will take your questions there as well, or you can send us an email. I'll put the email again in the chat, right? So someone asks, Haran, I know this is going to be a really technical response. If your manager makes a false report to the police against you, but you only find out 1 year later on your appraisal, can you bring this before the EOC if your employers do not investigate?
No, unless you can, again, you have to tie it to some sort of a status ground of victimization. If you could say that your manager did this to you, victimizing you because you lodged a previous complaint or that sort of thing, then that would be victimization. Or the manager did this to you because of your race, ethnicity, religion, that sort of thing, then that would be something that you could complain about. So while it might be a genuine issue to you, it may not be an EOC issue. It might be an issue that you would have to pursue with your trade union or something of that nature.
What about the time frame, the 1 year period?
Oh, yes. If you only became aware of it, say now, then you have 6 months to do it. So although using that example, although what your manager did might have happened a year ago, you said you only became aware of it doing a performance appraisal. Now you have 6 months in which to lodge a complaint with the commission. So if you became aware of it doing a performance appraisal, you would have 6 months from that date in which to lodge a complaint with the commission. If you sit on it, the Act provides that we can accept a complaint outside of the 6 months period in what is known as exceptional circumstances. But exceptional circumstances means just that. It has to be something more than just I was busy or something of that sort. It has to be, you have to give us a good reason why it is you did not lodge it within the 6 months.
Someone is asking, can I lodge a complaint against my employer for discriminating against me based on my Hindu name?
Well, yes, I mean, that would be perhaps race or ethnic discrimination or religious discrimination. It would fall under these three grounds. So yes, you can, but again, you would have to be able to point to what you think are the ways in which your employer is discriminating against you. So every matter is really a matter of evidence. But yes, the short answer is yes, you can.
We just got an extension. We got a few more minutes, so we can take a few more questions.
Okay.
Someone asked, what about not vaccinating based on religion?
Yes, it is. Technically, it could be a ground. But again, the difficulty is that the employer does have a duty of what is known as reasonable accommodation. And you would have to show what about your religion, for example, prevents you from taking this vaccine. It could be a ground. I mean, I can't really speak on it until you really lodge a complaint, because we would have to look at the actual facts of it to say, well, what is, what are the facts of this particular complaint? But yes, I mean, if you can tie your non-vaccination to a religion, it could be a complaint that we can at least inquire into.
Someone asks, if you are sent home for a claim that you have mental illness and you don't receive pay after 20 years, can that be considered discrimination covered?
If you're sent home because you have a mental illness, well, to begin with, the employer has a duty known as reasonable accommodation. But the challenge with reasonable accommodation, and we actually had a matter like this, is that part of it is that you, as this person with a disability, I'm a PWD, person with disability, you need to disclose to your employer that I have this condition, and perhaps discuss with your employer what is the accommodation that you need. When we do our presentation, a longer one, we always show a video where, for example, let us say you have diabetes. You need to discuss with your employer what it is you need. And it might be that I need a break every 2 hours to perhaps take my insulin, or I need a break every 3 hours. And the employer might be able to say, well, okay, we can discuss with you that, yes, I can give you a 15-minute break or a 10-minute break, or what could the employer do? So, you can't just wait until the situation has exploded and then say, well, you have a duty to accommodate me. These are things that you would need to discuss with your employer in advance, because it might be that the employer will say, that's to say the employer allows breaks for the employees. It might be to say, well, instead of allowing a half-an-hour break to you, I'm prepared to give you a 10-minute break every 2 hours, because reasonable accommodation doesn't mean that you have to get something above and beyond what the employer is willing to provide to all employees. The employer might say, yes, I'm willing to do this to you, but in return, this is what I want. So let us say you're a Muslim person and you say you want Fridays off to go to mosque. The employer doesn't have to give you this above and beyond. The employer might say, okay, well, I will allow you to take if you want 1 to 2 p.m., I will allow you to take your lunch hour during this 1 to 2 p.m. Or in order to accommodate you, you might have to work extra. You have to come back and work extra time or work earlier in the morning. It isn't a case of saying everybody gets 1 to 2 p.m. for lunch. Sorry, 12 to 1 for lunch. And I am entitled to extra 1 to 2 p.m. extra above everybody else. This is what reasonable accommodation means. It means that because it would be unfair to everyone, it would be unfair to the other employees who have to come back to work at 1 o'clock, to say that he got 12 to 1 off as our regular lunch hour and then 1 to 2 off for that. So I'm just using this as an example to show what reasonable accommodation means. So that when you say that you were sent home for your mental condition, each case would have to be determined on its own facts. Is it that you discuss with your employer that I have this condition and this is the accommodation that I need, and the employer refused to accommodate you? Because the employer has a duty to accommodate you. They have a duty to do what they reasonably can. So I need to clarify the statement very carefully. It's not that they have a duty to accommodate you. They have a duty to do what they reasonably can to accommodate you.
Someone asks, on the question of elapsed time, if my company is dragging out a grievance process, can I still take it to the EOC or the industrial court after the 6 months have elapsed?
Well, yes, you can. If you believe that your employer is dragging out the grievance process, but you would need to show, you would need to bring your, your correspondences, your emails and your letters, in other words, where you can show, well, we wrote to the employer and they took 3 months to respond and that sort of thing. What we also like to say is, once the 6 months have elapsed, then you need to become a bit more vigilant with your rights, because you can't simply say the employer dragged on the grievance process for 3 years. So that both the EOC and the Ministry of Labor and the Industrial Relations Act have a 6 months limitation period. So they're dragging it off, and the 6 month period has elapsed. You now need to become a bit more vigilant and start saying, well, okay, the 6 months has elapsed. Both the ministry and the EOC will accommodate you after the 6 months, but you need to start showing that you did things. You can't continue with the dragging on for the next 6 months and then expect us to accommodate you, because then we will tell you, yes, we understand that they drag it on for the first 6 months, but perhaps by month 7 or month 8, you need to have start doing something. So if the matter is going on for 6 months, perhaps you would need to start writing to your employer and say, in a gentle manner, we last wrote to you 2 months ago and we haven't heard from you, something like that. And then if they're not responding, at a certain point, you need to recognize that they're dragging it and they're trying to frustrate and delay you, and you need to take the next step. As lawyers always have this expression, you need to take the next step. So similarly, because you can't say, well, because we actually did have a matter like this. The person wrote to say their employer said 2 years ago they said, well, for the last 2 years I haven't heard anything, and we said, well, fine, we can understand you waited about 2 months or 3 months, but after say 3 months of not hearing or even 4 months of not hearing from your employer, you needed to have taken the next step. Either you write back to them, and even if you write, and then start taking it further.
Yeah. Someone asked, can employers put out an external vacancy during a restructuring?
Yeah, so this is always a very tricky issue with restructuring, where they're saying that they're downsizing, because we actually did have a complaint like this many years ago, where an organization said that they retrenched one person. They retrenched only one person, and they said they were doing a restructuring exercise and only one person got retrenched. Then we asked the organization, because it could be a genuine retrenchment. I mean, just because you retrench only one person doesn't mean it's fraudulent. But then we asked them, well, tell us more about this restructuring, and they couldn't tell us anything about the restructuring. Normally with a restructuring, you can say, well, we brought in a consultant, we did this report, we did this review, that sort of thing. So using that as an example, yes, they could technically, but then you would have to be able to justify why they did it, why they put out this advertisement. Because if coming out to the restructuring, they decided that they can replace 3 jobs with 1 job, that may be a genuine decision, but they would have to at least show that to say that they hired this consultant who came in, who did job evaluations, who did process mappings, all of these things that go on in a restructuring exercise. Coming out of that, this is what they decided. Because if, like that previous employer I was speaking about in a complaint, you said you did a restructuring, you retrenched only one person, but you can't tell us anything about the restructuring. What sort of strategic planning did you do? What sort of meetings did you have? What sort of internal consultations and stakeholder meetings, all of which are part of a restructuring exercise? Who did you bring in? Even if you don't bring in somebody, but if you do it in your internal person did it, you need to tell us something about it,
Yeah. All right. Someone asked, how does the Commission treat with complaints that do not fall under the Act under this jurisdiction, but might be covered under another, such as the US or the UK?
Well, we can only deal with what the legislation in Trinidad and Tobago provides, because we are the Equal Opportunity Commission of Trinidad and Tobago, and there is a principle in law that the only laws that apply to Trinidad and Tobago are the laws of Trinidad and Tobago passed by the Parliament of Trinidad and Tobago. And the same way, the only laws that apply to Barbados are the laws of Barbados. The only laws that apply to Grenada are the laws of Grenada. And the only laws that apply to the UK are the laws of UK. So even people in the UK, they can't look at, say, the laws in the US and say, I want to be governed by that. If you're in the UK, you have to deal with what the Parliament of the UK passes. So that, as I had said, we made recommendations for amendments. So sometimes in our recommendations, we do point out to the fact, and for example, with our recommendations on sexual orientation, we cited some of the laws in the US and said that we would like to be patterned after, these particular laws. So we can look at American laws and English laws and Canadian laws and Australian laws as a best practice or as a model for recommendations or amendments. But in terms of applying, we can only apply and follow what the laws of Trinidad and Tobago have, which is what the Equal Opportunity Act of Trinidad and Tobago provides.
Haran, you answered this question some time ago about the grievance process being dragged out. So the person asks, what if the union is the one delaying?
Well, that is going to be a more difficult situation because the union is considered to be your representative. So whereas you can point to employers' delays and employers dragging it out to get you somewhere, you can still try and you can still lodge a complaint, but because the union is your advocate, any delay that they make might be seen as a delay on your part because they are your advocate. Now, given that there's a collective, most places have a collective agreements, and you have no control over it. In other words, because under the collective agreement, things have to be done through a union, and going to the industrial court has to be done through a union. You do not have a right of what you call original access or direct access to the industrial court. And with the Equal Opportunity Tribunal, it's different. It's when you lodge a complaint with us, it's your complaint, and when it goes to the tribunal, it's your matter. It's not a NUGFW versus so-and-so. It is Miss so-and-so or Mr. so-and-so versus the employer. So it's going to be a bit more difficult. What we would say is once 6 months have elapsed and you haven't gotten anywhere, then you will have to start looking, at least lodging your complaint with the Equal Opportunity Commission to make sure that you get yourself within the timeline. We tend to be a bit flexible. You know, if 1 day after 6 months passes, we don't shut out complaints out 1 day after the 6 months. But if you're going to come 10 or 11 months afterwards, and you know, by that time 3 or 4 months would have elapsed, then you're going to have a difficulty there. So that once you see the 6 months have elapsed, then you need to start getting down on the matter and saying, well, you know, within the next week or two, I need to lodge my matter with the Equal Opportunity Commission, because the longer you take, the harder, the greater your obstacle, the greater your hurdle.
Yeah. I think that's it. No, wait, hold on. I have one more question here. How do I handle discrimination from standing up to my supervisor or manager for wanting me to do something unethical for them, so I won't lose my job?
Well, it's always a tricky question with everyone, you know, because standing up to persons who are above you always puts you in their direct line of fire, as it were. What you need to do sometimes, if you find that something is, after you've stood up to them, you are now observing certain things happen, you need to start documenting what is happening, because you're going to have to think about the realities. You're going to have to lodge a complaint either with a trade union, with the Equal Opportunity Commission. So you need to start documenting it. You need to start sending emails. For example, if you notice something is happening, you would need to perhaps respond to them with an email. Now, you need to be very careful. You don't find yourself in a situation of insubordination by making accusations against them. I always like to say, stick to the facts. Instead of saying, hey, you're treating me bad, or start to use adjectives, you're stupid, you're dotish, that sort of thing. We always tell people, no, avoid adjectives and descriptives and just fairly stick to the facts. So let's just say you were told, like, you know, a job was taken away from you. You can simply start documenting it in an email to them. On so you call me into the office, you told me this, you told me that, and this is the situation. As opposed to, and try to avoid the emotive arguments, as but state the facts. You need to, so in other words, you need to start building a paper trail, as lawyers call it. You need to start building a paper trail, and the best paper trail is contemporaneous, what we call contemporaneous evidence, not things that you wrote 6 months later down the road, but things that you wrote at the time of it happening. So you need to start documenting it, and that's really the only thing. You know, and because it's only if you want to escalate it further, this is what the evidence that you need to have.
Haran, what about taking this? This is just, you know, a follow-up to make sure that we're clear. What about taking notes of the employer treating somebody else differently than they're treating you, like using a comparator?
Yes, comparator. Sorry, yes, and thank you very much. The essence of discrimination really is that you're being treated unfavorably to someone else. If the employer is treating everybody badly, then while it might be an unfortunate situation, it may not be discrimination. And I always use the example, it was difficult to complain of discrimination on vaccination status when, all of the restaurants were closed. Remember, for a number of months earlier this year, all restaurants and bars and businesses were closed, so that you really couldn't say that, for example, the employees of KFC or Royal Castle were being discriminated against, or that I'm an employee of KFC and I'm being discriminated against because it was closed entirely. But if your employer, as Shelley correctly pointed out, is treating someone else more favorably to you, so that the job was taken away from you, but other persons got the job, or other persons are getting more, something more favorable. I mean, I can't think of examples right now, but you would need to be able to point to how someone else is being treated more favorably, and you would need to be able to document this on so on. So, or even if you're not aware, you document when you first became aware, because using the example of the person said only when they did the performance appraisal became aware that the manager did this to them over a year ago. Similarly, you may not know that your colleague got the job or got the promotion or today, but you might have heard of it next week, or you might hear about it. And then you could say, on so and so today, I heard or I became aware, because that's what you're gonna have to say, that sometime last week or the week before that this happened or that happened.
Yeah. Haran, thank you so much. You navigated these questions really well. We got a few more minutes, and I think we answered all the questions. If we, for some reason, didn't answer the question, you can probably put it into the chat or the Q&A. You can send an email to communications@eoc.gov.tt, or you can go on Facebook and look at our Facebook Live series every Wednesday at 11 o'clock as well. So, I mean, should we give a minute again to see if anybody wants to put any questions in the chat first?
Okay.
Right.
Actually, no, I was just looking. I'm not looking through the chat. I saw two persons ask, is it about becoming mediators at the EOC?
Oh, yes.
Yes. No, well, we don't have a roster or a panel. The conciliator that we have is an in-house employee of the commission. And currently, we are adequately staffed right now, so there's no shortage to Donnie and to Danielle. No, we don't have a roster, and there is no shortage right now, unfortunately.
All right. Thanks for that, Haran. Yeah, I think that's it. So we give 1 minute again. Haran, is there anything else you want to discuss while we wait for any more questions to come in?
Not particularly, because I think I don't want to start another area that that's in an area of itself. I mean, for example, I ran through sexual harassment, and I just want to mention, which I believe you mentioned as well, that we've actually done presentations that focus specifically on sexual harassment. So all of the areas that I discussed, and we've done presentations that focused on disability, so that all of the areas that I have touched, you can actually have a presentation in, based on that area. I wouldn't say alone, but focusing more on that area. So I just wanted to touch on it to let you know that it exists, and that you can request our services.
Yeah. All right. So you're welcome, Daniil, and all others. So let's wrap it up. You're welcome. People are saying very informative. Thank you, Haran. That was very informative, and I'm certain also very helpful for many of our attendees here today. And so we will wrap up our session now, and I want to invite all of you to check out our website, equalopportunity.gov.tt. You can go to our Facebook page, LinkedIn page, and YouTube page as well, and look out for our different public education efforts as we go along. So thank you all for joining us. Thank you, Haran, for your time and your expertise, and we will close off the session now.
All right, and thank you all for being here, and I wish you all health and safety during this period, and and thank you all.
Yes, and have a safe holiday, an enjoyable holiday tomorrow.
Yes. Yes. Oh, yes, happy Diwali, everyone.